How do you keep the jury from equating tragedy with malpractice? How do you overcome the weight in a courtroom of horrific, visible injuries? You do it through skill, you do it through clarity, you do it through simplicity, and you do it through great lawyering. Every trial lawyer has that one case, the one that pushed them to the edge, changed how they practice, or kept them up at night. This is Trial War Stories, and I'm your host, Andy Goldwasser. I sit down with great trial lawyers to unpack unforgettable cases, the strategy, the chaos, the pressure, and the moments that turn the tide beyond the transcripts and verdicts. And now, to the show. All right. Well, hey, I am really excited to be here with two of my favorite people. One, I have to say that for sure. And let me start with a little introduction. We have a special guest today. We have my dad, my hero, my mentor. I grew up in a family that consisted of my mother, who's overly dramatic, and my father, who, let's just call him straight-laced. And it created an interesting combination. When we would have dinner, I'd either get all this emotion from Mom or a complete cross-examination from you, Dad. But in all seriousness, you were a great, great lawyer. You're now retired. You were with Reminger for years, co-running the medical malpractice department over there, and just a prolific, great trial lawyer. And we're going to talk about one of your fun cases today. Next, we have my dear friend, Marilena, who I have known forever, who's just had a really cool trajectory. I think you started out actually as a nurse, right?
Correct.
And then you went with Eric Kennedy's firm and was working in plaintiff's work, then defense work at Reminger with my dad.
The best mentor ever.
I agree. And then after that, you're now doing plaintiff work again.
Correct.
All right. Well, I can't wait to dig in and talk. And really, you are truly, and I mean this, one of the best people I know, but the best medical malpractice lawyers I've ever met. I mean, you are absolutely phenomenal, and you have that reputation, and it's great to sit down with you today.
Thank you, Andy.
So I wanted to talk to you about a really interesting trial that we had, Dad, during your heyday, during your prime, sort of at the end, I guess, the end of your prime, where Marilena was involved and the two of you were trial partners. Tell us about the case.
Wow. Well, first, I could not have tried this case without Marilena, so we'll start there. What happened is that I received an assignment from a medical malpractice insurance carrier. And as we lawyers do, I get the assignment in the mail and I look through and see what it's about. And I am sort of a bit perplexed and shocked and anxious as soon as I read the file, because the plaintiff is an African-American mother who has lost both her arms and her legs to a disease called meningococemia, which is a blood bacterial disease which attacks the blood vessels of the body, and it first attacks the extremities if it's not treated promptly. It's an emergency situation. So here we get this case in, and we are to defend a medical malpractice lawsuit involving a plaintiff with no arms and no legs.
I can't imagine. You know, we deal with catastrophic injuries when we get more experienced in what we do. But to not only have a catastrophic injury, but one that's so visible, so emotional, so visceral for the trial, for a jury, that has to be something that is difficult to deal with. Not just emotionally, but then also how to present that. So please tell us a little bit more about the case.
That's exactly right. So the parties included the hospital and two physicians, as I recall. One of the physicians was our client, and our client was the emergency room physician who was the first medical provider to see the patient when she arrived at the hospital's emergency room. So first thing I had to do is learn about the medicine, as we do. I'm not a physician. So I read about the medicine. I said, oh my gosh, this is really a very serious, rare occurrence for some person to develop this bacterial infection. So looked into the file, tried to meet our client, the emergency room physician, only to discover that he had left the United States of America to return to his home country of Kuwait.
Oh, no.
So now we have to defend this lawsuit with a client who's no longer readily available.
Oh, my goodness.
So that led to quite a dilemma. Well, so now to move forward, of course, we did our discovery and all that stuff.
Well, before you get there, though, so you get this file and you do the initial analysis. Do you, do you get a team together? Do you do this to yourself? How do you decide who's going to assist you, if anyone, with the case?
Well, I was blessed to be able to have a team available, and the person that I chose to work with me was Marilena. And we're not here to be, accolades on all of us sitting in this room, but frankly, Marilena, in my opinion, was the most skilled, the most socially adaptable person to deal with this. Besides that, I wanted a female lawyer to help me because I'm dealing with a woman who's got children, and I thought if we have to go in front of a jury, this would have more appeal. And besides that, I've seen Marilyn. I've worked with her in the past, and she was extremely gracious and aggressive without being obnoxious in front of a jury, which is a real talent because you could be aggressive but totally turn the jury off. Marilena never exhibited that trait to me. So it was fortuitous that I asked her to join me to try this case. This is a lawsuit that is very difficult to defend without someone helping. I must confess that my memory is that some of the co-defense counsel tried it without the assistance of someone in their office, but I had Marilena. Now, I don't know where to go forward because the most interesting part of the case is how to get our client engaged with his own defense.
Well, let me stop you and turn this over to Marilena for a moment. So what do you remember sort of the intake, the initial stages of this case, how my dad came to you and what happened, what you thought, what did you do?
So, let's be honest. Your dad is one of the best trial lawyers ever, not just in Ohio, but ever. And it was a complete honor to be asked to help him and to assist him with this file. Once I saw what the damages were, though, I have to tell you, I was very anxious and very nervous because the potential here for a runaway verdict was enormous. The plaintiff was lovely and so visibly damaged, and it was heart-wrenching. It was heart-wrenching to participate in her deposition. So I thought it was an unbelievable opportunity to learn from one of the very best and to contribute in the most meaningful way that I could to try to defend this case.
Had you worked with my dad before?
Yes. Your dad was my assigned mentor.
Oh, okay.
And so I had the privilege of working with him before, but never on a case with this type of exposure. And quite candidly, that really required some great knowledge of the medicine and finding good experts and strategizing how do we best defend this case on the medicine, particularly given that our client was not readily available.
Makes perfect sense. So your client's not readily available. Did your client appear for any type of deposition at all?
No, did not.
All right. Tell us about that.
Well, so we have, Marilena is going to elaborate on this because this is where she really saved the day. So we have a client who we're trying to make contact with, and he was non-communicative. He wouldn't even respond to any of our attempts to reach him. And so I am having apoplexy. How do I defend a lawsuit with these potential damages without having a client to defend himself? So when we found out where he was located, the decision was made to go to him, right, because he would not come to us.
Literally go to Kuwait.
Literally. And so, because Marilena is who she is, it didn't take much persuasion. She recognized immediately how crucial this is to the defense of our lawsuit. And so off goes Marilena to Kuwait.
Oh my
And I'll
gosh.
let her take it from there.
What happened?
So it was the preparation was quite interesting. Learning what it is that I would have to wear or not wear, how I would have to conduct myself or not conduct myself. And I was ultimately given these great instructions by a tremendous paralegal by the name of Tammy Reesing. You will go to Kuwait. You are in a Western hotel, so
Okay.
you may wear Western clothes. This becomes important in a minute. So with a videographer, Steve from Sepharadi,
Oh my gosh.
we meet at Cleveland Hopkins and begin our journey from Cleveland to New York to London to Kuwait.
Oh my gosh.
And we become fast friends
I'm sure.
during those travels. When we arrive, we go directly to the hotel, and I have a piece of paper that has the doctor's name and address, but he is going to meet us at the hotel. Those are
Okay.
our arrangements, and we are going to videotape him. I'll do a direct examination to play this at trial as though he were present live, and the plaintiff lawyer is going to be by phone. These are pre-Zoom days. So he's going to be by phone piped in from the U.S. to Kuwait, and there was a time zone difference.
Okay.
So when we arrive, we quickly find out this doctor's not coming because we're waiting and time's ticking and
Oh my
there's
gosh.
no doctor. And it dawns on me that there's only one thing to do. We have to get in a cab and we have to go to his home and we have to persuade him to come because we are there. Here's the part about the clothes. I was not covered in the proper manner to leave the Western Hotel.
Oh my
So
gosh.
no cab driver would talk to me. They would only talk to Steve. We arrive at the doctor's home.
Well, how did Steve even communicate
Oh,
with
he
you?
handed the taxi driver the piece of paper pointing. and we got there. We got there, knocking on the door. A housekeeper answered the door. And clearly he was trying to evade us. But I think ultimately he was so stunned that we were at his door that he said, okay, I'll shave and I'll come down. Meanwhile, I'm calling your dad saying, stall.
Right.
Make up something because of this time difference. Stall. We're going to get him there. And we did. And he went on video and we did a direct exam.
Amazing.
And the plaintiff lawyer conducted a cross-examination. And we completed that assignment, turned around, got on the plane, and came home.
That is unbelievable. And then you use that video at trial.
Yes, we did. And this witness, he was fantastic. He was brilliant. He was a cardiothoracic surgery fellow who was in his fellowship here in the States, was moonlighting at the hospital as an emergency room physician, and took his talents back to his home country to start a cardiothoracic program there. He was as articulate as can be. He was able to explain his logic and his thinking. This lovely woman presented to an emergency room. It was July. She had a fever. She had no rash. And he had two options. I either admit her or discharge her. Because he couldn't really place why she had a fever, and in an abundance of caution, he actually did the very right thing and admitted her to the hospital for further evaluation by an infectious disease consultant. And it absolutely resonated with that jury that this gentleman who had one of two options absolutely did the right thing. And he was so confident, charismatic, and articulate in his manner of explaining. He won the case for himself.
Do you think that it helped him by being by video
Yes.
as opposed to being live? I mean, did it help in front of the jury, the fact that this guy is comfortable in his home country, being able to testify on video as opposed to live in front of a jury?
Yeah, I think his personality was so strong and his story quite compelling in that he took his skills back home. It's a nice story
It is a
to
nice
tell.
story.
And he was very relatable. And I think it was better to have him by video because your dad and I knew exactly what that evidence was going to be. The cross-examination was not perhaps what it could have been live at trial. And I think it was to everyone's best interest from our defense to have that solidified before we walked into the courtroom.
That's an amazing story, Marilena. So let's talk a little bit about the trial itself. So I'm a plaintiff lawyer. There's sad to say, but there's nothing that's more exciting as a plaintiff lawyer, and you experience this too, to have a case where your damages are off the charts.
Yes.
And here you have one. So as a plaintiff lawyer, I'd be looking at a case like this as someone who would say, boy, this is a career case for me. And here you are on the defense. You have an absentee defendant that you're defending, and you have these horrific damages. How do you develop a trial theme for a case like this?
Well, first of all, I'm going to back up for just a second, and I will answer your question. Marilena is being more than gracious. First of all, this client, this doctor that we had, was initially very combative. He did not want to be involved. He felt that I live in Kuwait now. This is not my problem. This is your problem. And I was very, very concerned that he would be a hostile client. So, but Marilena did conduct a tremendous, persuasive direct examination. Now, what was interesting, plaintiff's counsel, of course, is of the mind that this is going to be a super retirement case for him. He's going to make zillions of dollars, and I could understand his thought process, considering the damages. But I thought he would object to the fact that he had to cross-examine by telephone, and that we didn't have an obligation to bring the defendant to the United States. And he conducted a telephone cross-examination, but it was not particularly persuasive. And Marilena out-lawyered him upside down, backwards, and forwards. And it wasn't that he was an incompetent lawyer. He just was so overly confident that this is never going to fly in the courtroom that he was willing to do it by telephone, because I'd much rather have this defendant on video from Kuwait than come to the United States and testify.
I could understand that strategy going in, right? You don't know how this person is going to present, so there's risk and there's benefits, and I understand his decision-making process. But so, Dad, I mean, one of the things that we do now, which I don't know if you did back then, is we would focus a case like yours quite a bit, and we try to develop the right theme so that we could present that theme to the jury. What did you do to prepare the case?
Well, when you're defending a case like this, where you have a plaintiff who's very sympathetic, I mean, how do you do this? You don't put the plaintiff on trial. You just don't. So you have to put the medicine on trial. And so it became a trial to discuss a very rare bacterial blood disease. And so that's where we really focused our case. And so we retained excellent witnesses. We were prepared to cross-examine the plaintiff's experts. And so we literally, I personally essentially ignored the plaintiff herself for the bulk of the trial, devoting almost all the attention on the medicine. And that's how we approached the case.
And from the plaintiff's perspective, Marilena, do you remember, how did the plaintiff present the case? Did they try to build on the emotions of it all?
So I have to emphasize what your dad said. I think, and rightfully so, with the damages that were involved in this case, the plaintiff's counsel really believed this was a foregone plaintiff's verdict of an incredible dollar amount. And so their strategy was to focus on the plaintiff, right? But she wasn't in the courtroom. So building drama for her ultimate entrance into the courtroom on day 3 or 4 of trial. So the jury was in a position where they were waiting with bated breath to see the plaintiff, to meet the plaintiff. And in really tremendous dramatic flair, the doors of the courtroom open and the plaintiff is brought in on a stretcher. And
Wow.
the visual, you feel that pain, that angst, no arms, no legs, on a stretcher, wheeled in by ambulance personnel. And she was a compelling witness. And in my analysis, then a grave error was made. The plaintiff counsel at the conclusion of her direct examination kissed her on the cheek. And I don't know if it's my perspective as a woman, as a lawyer, as both. At that very moment, it felt just so incredibly wrong. So incredibly wrong. And I felt that the jury reacted in that same fashion. It took away from her, put the emphasis on the attorney, and it just didn't play well at all.
Almost over the top.
Over the top. It was. It felt uncomfortable.
So which one of the two of you cross-examined the plaintiff?
Marilyn, I don't recall.
I don't.
It must have
either.
been you.
Yeah,
I'm sure it was you.
I would bet it was me, but I honestly don't remember.
And I assume it was a soft
so
cross.
soft. When I tell you I was uncomfortable at her deposition asking her questions, I just wanted her to be home and be comfortable.
I could see that. You know, one of the things that you mentioned to me, Marilyn, and I know you even teach this now, is the importance of building credibility first. When you said that to me, it really resonated. And I think I mentioned to you that one of the mistakes that I have made over the last 20-some years is putting the defendant on cross-examination early in my case, usually my first witness, going after the defendant as if on cross-examination as my first witness. And meanwhile, I haven't built any credibility with the jury, and the jury's looking at me saying, why is this guy picking on this poor witness? Did it take you a while to learn that as a lawyer? Did that come from defendant cases? Like, how did you come up with that?
Well, no, it took me a minute, Andy, because on the defense side, you watch trial essentially for the first week. I mean, you're an active participant, but you're not putting on your case. Your story comes second. As a plaintiff lawyer, as you well know, right, you're telling your story for the first time. And you have to stop and take a breath and recognize this jury doesn't know me. They have no idea if I know what I'm doing or if I don't. And in all likelihood, their bias is in favor of care providers, right? Because these folks go to school and take an oath and take care of us. And so in order for me to best illustrate what the error was, to best represent my client, I need to build credibility that I know what I'm saying, and I have to be respectful as I build that credibility. Once I've built it, then I can expose the error through an effective cross-examination. So now I'm rethinking, who do I call first? Because you can't come out hot and expect everybody to understand what your story is. You haven't developed it yet. Yeah, whereas on the defense, the story's been developed and is well known by the time you stand up and are talking to the jury.
That's such an interesting point. And I think that bodes really into what you were saying earlier, Dad, about focusing the case on the medicine. Was that your way of establishing credibility with the jury, or you just felt that that was the best defense, or was it a combination of the two?
It was a combination of the two. First of all, you would not even begin to think of attacking the plaintiff under these circumstances. The truth of the matter is, if she had gotten to the emergency room sooner, she may well have been able to salvage her limbs. But I'm not about to criticize her for sitting around her home being desperately ill and waiting for the last minute to arrive at the hospital. So you are obviously very empathetic and supportive of the plaintiff and the dilemma she has in raising her children. In my considered opinion, with the benefit of hindsight, a different lawyer with a different personality may well have prevailed in the case. I think the error that the plaintiff lawyer made is that he was so overconfident, Marilyn alluded to this, that this is a case he can't possibly lose, that he was sort of, I don't know how to describe his personality, he was sort of disdainful of the defense. Like, how do you even have the nerve to come into a courtroom and try to defend this case? And once we put on a credible defense of the medicine and establish for the jury what a rare disease this is and how difficult it is for physicians in this position to treat a patient like this, it sort of got him off kilter. Like, God, man, you know, they really do have a way to defend this case. What am I going to do now?
And I love that approach because the medicine's complicated. So you have to explain that to the jury. But the defense is simple, as Marilena described. You have two options. You admit, right? Or you discharge. And here the doctor did the right thing. He admitted. And when you take this complicated medicine and you simplify it and distill it to that fine of a point, to me, that's what's great lawyering. And one of the things, Dad, that you've taught me very early on is the difference between good lawyers and great lawyers are the great lawyers have relevant minds. And you use that term a lot. And it has always resonated with me. And I try very hard in my practice, not always successfully, but that's what I try to do, is focus on what is relevant, take what's complicated, and simplify it. And it sounds like that's what the two of you did in this trial and did it well.
So one thing about your dad, Andy, is his courtroom demeanor is it's a very commanding presence in an incredibly intelligent way. In other words, he controlled the knowledge of the medicine in that courtroom. Everyone, and by everyone, I mean jury, judge, bailiff, was looking to him when he stood up to learn that medicine. So we've left out that there were co-defendants in the case. So we had the emergency room physician, and then there was an infectious disease physician who was also being criticized, and the hospital nursing personnel. And your dad actually defended that case for everyone when he would stand up and discuss the medicine. So that what really happened is it did take the plaintiff counsel off kilter, because I don't think he saw that this defense, this explanation of the medicine, was really going to ultimately exonerate everybody. And it was Gary Goldwasser who did that in the courtroom. And I think that's what won the case, was being able to explain this medicine, explain it for all the caregivers without ever once saying anything about the plaintiff other than we were so empathetic and sorry for what had happened with her. And I think juries watch everything we do. I'm so anal about my trial tape, how everything looks and how I sit. And this was in the day when trial demonstratives, the companies that come in and help with trial.
All these electronic graphics and these giant timelines and all that stuff.
This was all new. And the plaintiff lawyers, one was from out of state, had hired a company to help with their trial graphics. And there was one document, I don't remember what it was, but one document that was being used over and over and over again. And they had just had it up on the screen for a direct. And your dad said, oh, can you put that back up? I'm going to use it for cross. And they said, no, if you want to.
Did they say that in front of the jury?
1,000,000%. They said no in front of the jury, and something along the lines of if you wanted it, you could have brought it in.
I just don't understand that. I mean, how can they think that that will help them with the
So
case?
that was the mindset, though, where your dad says disdain of the defense. I want to help tie that together. That was sort of the mindset that I think going into the case, oh, okay, I get it. You have a big case with big damages. But now we're in the courtroom and the dynamic has changed, and there's clearly one person here who's leading the charge with the defense of the case, and it's the one person now you just spoke to in a manner that really is not going to be well received. And you sort of are shooting yourself in the foot by the way you're doing this.
How many defendants were there at trial? Because I know one settled out, correct?
Correct. One settled, and there were two: the hospital, and the emergency room physician.
Was there any pointing the finger at all?
No.
And did the hospital point the finger in your direction?
No, not at all. It was clearly a united defense. But I notice you're here for trial war stories, but to be generic in the conversation, Andy, I always believed that one must keep it simple. You have to, as you said, you've got to be relevant, and you can't just be all over the place. And so our job as defense counsel in a case of this magnitude, and obviously we picked out this case as the example of our discussion here today, is because there are very few cases in civil law which have potential damages like this. I mean, in today's inflationary market, if a plaintiff received an award in a case like this, I think you would agree that you're talking about multi-millions of dollars.
With for sure, that would be the case. I mean, verdicts are really trending up for plaintiffs, as Marilena can attest to, and there's no doubt that this would have been a significant probably eight-figure verdict,
Yeah,
right?
I think her life care plan was in the double-digit millions.
Oh.
So it really, I mean, I know we're being repetitive here, but what you do is you establish your credibility by discussing the medicine in a credible fashion. And that was a monumental task to discuss a very complicated, rare disease, to make it so that the jury could understand and get themselves in the shoes of the defendants. And as Marilena has made reference, this doctor who is here as a cardiothoracic fellow is confronted with an extremely rare disease, a patient he's never seen before, who just is brought into the emergency room in extremis. What is this poor fellow supposed to do? And saying it in a presentable fashion turns the whole thing around to the point where the jury is now empathetic to the defendant.
Sure.
Oh, this poor doctor, look what he had to deal with. And he's got to live with this lawsuit hanging over his head when it wasn't his fault that this poor lady with all these children came down with this god-awful bacterial infection. He didn't cause the infection. He was just doing the best he could. And so that was the general theme of the defense.
And just to give you an idea of how effective your dad was, the hospital lost as to standard of care.
Wow.
The hospital won on the issue of causation, and that is due to one man, and he's sitting to my right. And explaining the medicine is what allowed that jury to understand that even though they found the nurses had not acted according to the standard of care, they didn't cause the injury. The illness did. It was huge. The explanation of the medicine was a pivotal factor, not only in the verdict in favor of our client, but also with respect to the verdict in favor of the hospital. And I think if the hospital lawyer were sitting right here, he would say exactly what I'm saying.
Wow. Well, that's really interesting. I mean, there's two other things that I'd like to touch on. One is, Dad, one of the other things that you've taught me as a trial lawyer is, we have talked about the differences between what I do on the plaintiff side and the work that you did on the defense side. And my brother, your other son, is also a defense lawyer. And we talk about how we as plaintiff lawyers pick and choose our cases, right? A client comes to us. If we don't like that client, we don't have to take the case. You as a defense lawyer didn't get to pick and choose your clients, but you always made it a point when you tried these cases to humanize your client and put yourself in your client's shoes. Can you talk a little bit about that and why that was so important for you as a defense lawyer?
Well, of course, the focus of my law practice the last 30 plus years of my practice was defending physicians in hospitals. So one has to, as Marilena has alluded, one has to allow the jury to appreciate what it takes to be a skilled physician and what the physician is confronted with. And so you've got to humanize the doctor. And I must confess to you that the few cases, although I've lost my share of cases where there have been plaintiff verdicts, almost universally the reason the case was prevailed by the plaintiff is because the doctor was unable to humanize himself. He became full of himself, like, how could you even question me? I'm a doctor. And you've got to see to it that your client does not develop that kind of persona in front of a jury. And that's tough.
That's hard with doctors.
However, it's interesting because here now the doctor is relying upon me. He's so used to patients relying on him Now he's coming to his lawyer. Lawyer, I need your help. I've got a problem. Lawyer, what do I do? How do I get out of here?
Right.
So it gives me the prerogative to sit a man or a woman, physician, whoever it might be, and explain the facts to them about what it takes to win a case at trial. And now I'm in charge. You're not in charge. You're going to follow my advice, my lead, and we'll get through this. And so generally, that's the approach that I would take.
How many cases do you think, Marilena, let me ask you this. How many cases, just on average, do you think are won or lost by virtue of how good or bad the plaintiff is and how good or bad the defendant is?
So it's an interesting question, Andy, and I think the majority. I mean, I think experts cancel each other out in large part.
I do too.
I think that they're neutral. And I think it's the strength of really the defendant. If the defendant is strong, likable, compassionate, are able to explain the medicine in his or her decision making, I think that's a defense verdict. I really do.
And the reason I ask that question is twofold. First, here you have a client who's not appearing live, so we go back to that, who's from Kuwait, a Middle Eastern country, not an easy stigma to overcome, right? And you have a sympathetic plaintiff. So in your case, you're relying really heavily on experts, I have to imagine, right? I mean, especially if you're trying a medicine case. So that's the first thing. And the second thing that I've learned as a trial lawyer is I think it's important in any story to have a good guy and a bad guy, right? You have to have that. Did you have a bad guy in your case? And if so, who?
We did have a bad guy. It turned out to be the plaintiff's attorney.
And that happens a lot, whether somebody has to be the bad person in a courtroom. And in your case, that's interesting that it was the plaintiff lawyer.
I didn't know the plaintiff lawyer very well. I didn't know him hardly at all on a personal level. And my impression is he's not a bad person. He was just so overly confident about his case that he became disdainful of everybody else. And that made him a persona non grata in front of the jury. And he lost his own case. And by the way, when the defense verdict came in, I thought we'd never get him off the floor. He was.
Well, we're going to talk about that. Hold on a minute. Hold on. Don't get there yet. Marilena, do you agree with that? That in your case, the bad guy was the plaintiff lawyer, or was it some other witness?
No, I agree with your dad. You know, as you watched it unfold on day one, there was no bad guy. But as the trial took on speed and witnesses started to get put on the stand and behaviors started to manifest in the courtroom, it became the plaintiff lawyer.
I find that so interesting because on so many levels, but the life of a trial, how a trial just evolves, right? You work your tail off getting prepared for these. You think about every word and rewrite every word 100 times, and then you go in there and it changes quick. And the good trial lawyers are able to change with it. So just an interesting point. So here you are. Tell us about the verdict. Marilena, tell us what happened.
It was Thanksgiving.
Oh, boy.
It was Thanksgiving, and the jury went out on a Tuesday, right, Gary? The Tuesday before Thanksgiving.
I don't recall, frankly.
I think it was the Tuesday before Thanksgiving. And although, as we sit here today and reflect on it, we can tell you about these moments in trial that were uncomfortable and where we thought the plaintiff lawyer had made some missteps, the kiss, the denial of the opportunity to use the video. When that jury went out to deliberate, we were nervous.
I'm sure.
Yeah, we were really nervous.
I'm sure.
And it's Thanksgiving. Let me repeat that. It's Thanksgiving. So
were they out over Thanksgiving?
Yes, they were, Andy. And you know, the traditional thinking is the faster the jury comes back, the more likely it is a defense verdict because they didn't have to think about the various questions that they have to answer.
And have Thanksgiving dinner with their family where they're thankful for everything.
Yeah.
And then you have a plaintiff with no arms and no legs who's not thankful for anything at the moment.
Correct. And they came back on the Friday after Thanksgiving.
Oh, my gosh.
I don't think that you and I had a very peaceful Thanksgiving that year.
I mean, yeah, you know, it's the saying goes for whether you're in a criminal case or a civil case, the worst time of trial is while the jury is out and you're waiting. While I'm in the middle of a trial, I'm much more relaxed than I am after the jury goes out to deliberate. That is god awful stress. Let me tell you.
So you got the call on Friday to come to the courthouse? Is that how it
No,
worked?
This is how I'm remembering it, Andy. If it was the Wednesday before or the Friday after, I honestly don't know, but they were out 2 days.
2 full days. Okay.
It was awful.
Did you wait at the courthouse? Because, Dad, I can't imagine you waiting anywhere.
No, I mean, I don't remember, Marilyn. I would typically go back to the office and, close my office door and pray. I mean, what can you do? I mean, there are so many backstories of this trial, Andy, that we haven't even discussed. One of them was the jury selection. Remember, we have an African-American woman, and the plaintiff's attorney was absolutely horrified that if we would excuse a potential juror who was an African American. And that occupied probably a half a day in judges' chambers talking about the appropriateness of picking a fair and impartial jury. That's just as an aside backstory.
Did you have a jury in mind that you wanted before this case? Like, was there a certain type of juror that you were looking for?
Not
or you
for
didn't
me.
even think it through that much?
Well, I mean, generally speaking, when you're defending a lawsuit like this, you want somebody who you think is going to be able to relate to the medicine and just not respond emotionally to the obvious emotion of this case. And, it's interesting. We talk about picking a fair and impartial jury. That's not true. You want to pick a jury that's going to be partial to you. And so lawyers talk about fair and impartial because they go through that mantra with the jury. But a good trial lawyer is looking for a jury that could potentially have bias for his or her side.
Which I keep going back to this because it's just so interesting to me in the modern day of trial where we're looking for the right jurors. What do, Marilena? We hire focus groups. We hire jury consultants. I mean, on big cases, right? And we scour social media.
Yep.
We do anything and everything that we can. It sounds to me like you just had some general thoughts as you went in and you put on your case and you did it exceptionally well. Am I saying that correctly? Or was there more to it than that?
No, I don't think, I mean, rather than belaboring what we've already discussed, I think that's essentially it. I mean, I've always taught you and others who I work with, keep it simple, stupid. I mean, really, you cannot overthink a case. You've got to relate it to how is the jury going to respond to the facts of this case? And I used to spend a lot of time sitting in my office behind a closed door, just sitting there thinking about this, thinking about it and thinking about it. To me, that is an important part of trial preparation. But I'm getting off kilter because Marilena is the professor of trial tactics. And that's really
you're not getting off topic because it's such an interesting comment. And Marilena, we need to be reminded and need to be reminded regularly of the danger of over-trying a case. And so it's a good lesson to be reminded of.
So your dad just said something, and I have to share something with both of you. Judge Michelle Sheehan has been a guest professor during my trial tactics class. And when she came to speak to the class, Gary, she told them that the most valuable advice she received in her career was from you. And you told her that the most important part of the job was to think and to close your door and think. And she does that routinely. And she, honest to goodness, just said to my class, wow, it is the best, most valuable advice I can pass on to you. Please actually do it.
Wow. That is great, Marilena. Thank you.
Thank you, Marilena. Thank you, Judge Sheehan.
Yeah, right.
I didn't know that.
Well, Dad, you have built an incredible legacy that continues to this day in the Cleveland legal community, and we're all grateful for it. I certainly know it has opened up a lot of doors for me personally, And I am so appreciative of those opportunities. I hope to goodness that I haven't let you down.
Oh, you haven't at all.
So-
You've made me proud. I know this is a mutual admiration society, but it's nice to be able to say to your son, wow, you make me proud. And
Okay.
as you know, I've always preached, nothing is more valuable than your reputation. Nothing. So always maintain credibility, truthfulness, reliability. It will serve you well.
Thank you. I really enjoyed this conversation. Thank you both so much for being here.
Andy, thank you so much. This was so much fun. I loved it. Thank you.
Thank you.
I have other cases we could talk about.
Yeah, we'll save that for another podcast.